SJC-11502, Commonwealth versus Dunn.
Mr. Black, good morning.
Good morning. If it may please the court, Mr. Chief Justice. My name is Attorney Alan Black, and I represent Mr. Dunn in this matter. I'd like to just start out with the argument two. I believe I can make sure. I believe I can make short shrift of argument two, but I think it's a remedy without a difference. Count two was charged as armed assault with intent to murder. The jury verdict slip said assault with intent to murder. The jury came back, asked assault with intent to murder. They came back with a guilty. But then he was sentenced to 15 to 20 consecutive, which would be the maximum on the armed assault with intent to murder, but only 10 was the maximum on the what was read in public. I cited some. There was the trial judge actually brought it to the attention of defense counsel. Defense counsel said, "Let me think about it." Then he objected, and then he made a motion also on the judge's behest. He made a motion for judgment notwithstanding the verdict orally, and then the judge denied it. That was the end of it, and then was sentenced to the max on the other, on and after.
So let's assume you're right. Well, first of all, two questions. One, was the jury still there? Was the jury asked to clarify?
No.
Or not? Okay.
No.
And secondly, are you claiming the remedy is that the count should be dismissed, or the remedy is that it should be found guilty essentially of the lesser included?
I think the motion was a judgment notwithstanding the verdict, but I do think the remedy as laid out by the courts is that he has to be found guilty of what the jury read in public.
Should be the lesser included.
And that would be the assault without the armed, and then he would be resentenced to maybe whatever the judge wants to resentence him, but up to 10 years. And if he wants to make that concurrent or on and after, he could. But you know, he's doing a life on count one, and then he's doing a 15 to 20 on count three on and after, so it makes no difference. But I do think that's clear error, and I cited the cases that said that.
Okay. Let's focus now on the ones which
are more important.
May make a difference in terms of the actual sentence.
Thank you. Count one, I'd like to start with. This is a case that was a clear insanity defense. There was no issue as to the perpetrator in this case, and there were two witnesses, one Dr. Fife from the Commonwealth and Dr. Abdow for the, two witnesses, two psychiatric witnesses, and Dr. Abdow for the defendant. Dr. Abdow said there was a criminal responsibility issue. Dr. Fife said no, but then Dr. Fife was asked to comment on what Dr. Abdow testified the defendant said to him. And she said that the statements were fabricated. And then the judge said, "Are you saying that the statements were fabricated or the report was fabricated?" So I think the judge was asking, is the defendant lying to you or to him, or is Dr. Abdow lying to you?
Did Judge Fishman strike all of that evidence?
He did. Moved to strike.
Gave a curative instruction.
And gave a curative instruction.
Was there any objection to the curative instruction?
Yes. Well, I think there was, because he asked for the word, it was inappropriate to do what she did. And the judge refused to give the word inappropriate and gave a different instruction that and the instruction is on page...
May not consider any comments on the credibility of any witness in this case, and in fact, when it comes to the issue of credibility, the issue of the credibility or believability of a witness is solely your responsibility in this case. That will be ultimately your determination to determine whether all or part of any witness's testimony is believable or credible, and I'll be giving a far more detailed instruction on that issue during my final instructions.
You read it perfectly.
Thank you.
I was about to do that, but thanks. The detailed instruction that he gave at the end was just a regular, didn't refer to this, just a regular instruction about...
So this is an inadequate instruction, you think?
Well, can I jump over the instruction for a minute?
And I read so nicely to you.
And I'll go back to the instruction, but the thing that's interesting is, I know all of you know who Dr. Fife is, and Dr. Fife testifies. I've had her in trial cases, but Dr. Fife testifies on almost all of the trials now regarding this issue in the Commonwealth. Almost all. She's the go-to person. She knows better than this. And she did it 3 times. And I labeled it 1, 2, and 3. I mean, she kept on doing it, where the judge finally had to call everybody sidebar and say, listen, no more. Tell her to stop. And then she stopped. So my question to you is, yes, the first question is, did the instruction satisfy, was it an adequate instruction? I would say no, because he didn't use the word inappropriate and it was objected to. But can I throw something else in? Why can't we sanction the Commonwealth for having a witness who clearly knows what she's doing from saying something that clearly prejudiced the defendant?
Now, my recollection was, and you can correct me if I'm wrong, obviously, that the district attorney wanted to just take a little break so that they could speak with with the psychiatrist and basically set her straight.
Right.
There's an objection, and the judge wouldn't allow the break in the testimony. It's hard to say that the Commonwealth wasn't trying to do the right thing there.
Yes, after she testified 3 times.
Well,
and-
but the questions were not inappropriate, I don't think.
Weren't they?
Were they?
Well, I mean, I have the exchange here, but they kept on asking. Well, and even, okay, let's say Dr. Fife was just doing this on her own. Let's say she wasn't responding to the Commonwealth's questions, and let's say she knew what she was doing, and in spite of what the Commonwealth was saying, and in spite of the objections, she was going to say it anyway. I mean, she is a witness for the Commonwealth. She works for the Commonwealth. She was hired by the Commonwealth, and she knows better. I mean, she knows better. This is not like the Cunin case where it was they said it was an inadvertent remark. She said it 3 times, and it kept on going. And so we have a case where what the defendant...
So you want us to find facts that there was intentional misconduct?
There was.
No, that's not my question. You want us to find those facts?
Yes. I mean, I don't know...
I don't like your chances on this argument, so why don't we let's turn to what is really the core issue in the case, I think, which is the issue of insanity. I mean, it was an insanity case. It was certainly not a frivolous claim of insanity. Was there any motive that was ever ascertained here?
The Commonwealth wanted to or did put in a motive, a financial motive, but really the financial motive was really weak.
So the question is essentially the jury considered it. There was evidence that went both ways. The jury decided that the Commonwealth had met its burden. Why should we alter that under 33E?
The jury decided to meet their burden after...
The jury decided that the Commonwealth had met its burden.
The Commonwealth met their burden after hearing from the Commonwealth's only witness, Dr. Fife, who opined that Dr. Abdal lied.
Well, she also found other things in terms of the extent to which he had tried to clean up and conduct which indicated knowledge that he had committed a crime, and then efforts to either seriously injure or kill the
wife.
The wife when she had come in, and then apparently efforts to even arguably plant evidence in the car of somebody else. I mean, there was other evidence here which would support the verdict. I don't think the question of whether or not it was an issue of sufficiency. You don't present it, but the core question is, why should under 33E we do something other than the jury did here?
You have a defendant who clearly has a serious history of schizophrenia, clearly a serious history of mental illness for a very long time. I have in my facts all the different incidences. It was testified to by the spouse. It was also testified to by his friend. I think he characterized him as a zombie.
But that all seems to be after 2007, right? The spring of 2007 was when that began?
Yes, all of a sudden, yes, that's true. He seemed to not have those signs until a couple years before this happened. And, I mean, it's not that unusual to develop those schizophrenia or paranoia later on in life, and he did.
But he was in his 40s at the time?
Yes.
And he he had children.
Yeah, yes, and a wife, married for several years. And then his best friend also testified that all of a sudden, he was acting very, 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 very strange, including, I think there was this whole thing about the computer and about messages coming over. He thought messages were coming over the computer. Finally, there was a message from Lebanon that he interpreted as, okay, now I'm going to die. And that's when he started acting stranger and stranger and stranger. He started taking, there was a suicide attempt, he started taking Klonopin, took, I think, 30 at once, had to go to the hospital, but they didn't keep him, and then he went home. And this happened at a job. He was just, I think, I don't know, putting in sprinklers? I mean, he was working there, and really out of the clear blue, he goes down and does this in a horrific manner.
Was there any question about there being some sort of dispute with with Robert?
I believe that again, the Commonwealth put in some facts that there was some beef between the two.
Yeah.
But to me, the beef, there was some financial thing, and to me, the beef seemed very, very, very weak. It all of a sudden just, I mean, even if there was a beef.
He'd never blown that way before.
No. And look what he did.
Yeah.
I mean, he certainly, even if there was a little beef, he certainly overreacted in a way that really, it wouldn't be a normal reaction to the beef of this nature. We're not talking about a major beef that affected his,
He was hospitalized twice.
Yes.
In 2007.
Yes.
And it took 3 years after the incident for him to be found competent to stand trial?
Yes. Thank you. There were many, many continuances at Bridgewater. I think there were 3 incompetent evaluations that kept on being, the case was continued for a long time because he was deemed incompetent. I think Dr. Carroll also testified as to his mental condition.
But he didn't offer an opinion on his criminal responsibility. Oh, there were only 2 opinions on that, right?
No,
Fife
and
Ablow.
Correct. And Dr. Carroll doesn't. The doctors at Bridgewater will not offer an opinion as to criminal responsibility, and he's very careful, Dr. Carroll, about not doing that. What he will say is he's suffering from, and he did testify that he's suffering from schizophrenia and paranoia. He just wouldn't say that would involve, criminal responsibility. Therefore, he didn't know but they won't do that at Bridgewater. The doctors at Bridgewater are told not to give those kinds of opinions.
Dr. Fife also said he had psychosis, not otherwise specified, right?
I believe so.
So that's the same diagnosis that Dr. Ablow diagnosed the defendant with, psychosis not otherwise specified?
Both diagnosed the same mental illness, but they came up with a different opinion as to what his criminal responsibility is.
At the time, yeah.
Yeah, and she did not clearly believe the statements of the defendant about the computer, about being attacked, about people in his head, that's what she was talking about. She didn't believe those statements, or again, didn't believe either Dr. Abdow putting those statements in there or that the defendant made those statements. But yes, she came up with the same conclusion. That's why this court should reduce the second degree.
Okay.
Can I just briefly touch 3? I mean, I understand it's a routine. It's an instruction under Carroll, which came out 5 years after this case, but it was the same kind of instruction the judge gave the jury. And even though in Carroll they said it's not a substantial miscarriage of justice because he gave the instruction that was
Carroll, you mean Chappelle, I think.
Chappelle, I'm sorry, thank you. That he gave the appropriate instruction at the time, and yes, he did. But it was an instruction that the jury could instrue that he would be out in 6 months. And this is a case where I believe that instruction would have made a difference and that instruction mattered. If there's nothing else, I would ask that I would rest on the briefs.
Thank you.
Thank you, Your Honors.
Ms. Cusick, good morning.
Morning, Your Honors. May it please the Court, Tracy Cusick for the Commonwealth. Your Honors, the Commonwealth is asking this Court to affirm the conviction of the defendant for the murder of Robert Moore Sr. and for the brutal attacks that resulted in convictions for crimes against Robert's daughter-in-law, Nancy Moore.
Before we go into the murder, with regard to the assault with regard to Nancy, what do we do with the verdict?
Your Honors, there is a case, Rivera, where this court did allow a verdict to stand with similar, not exactly on point. In this case, the verdict slip is certainly missing a word, and the way it played out is that the clerk was reading the charge to the jury from the verdict slip. The jury said guilty. The judge interjected and said, "Is it armed assault with intent to murder?" And the clerk said, "It says assault with intent to murder." And the jury affirmed their verdict and then were released. And then when the judge returned for sentencing, that's when the issue was raised. So I think it was likely past the stage where the jury could be asked to clarify what they had intended. But in this case, certainly the indictment, which said armed assault.
And that was read to the jury?
That was attached. I went to the clerk's office in preparing this, and it is in the record appendix of the Commonwealth, but it was 2 pieces of paper stapled together. So certainly they had the indictment with them with the correct word on it.
And he was instructed on armed assault.
Instructed on armed assault. The Commonwealth's argument was mentioned armed assault, and certainly the facts wouldn't permit a view of anything other than it being armed assault, where there's the dent in Nancy Moore's locket, and the injuries to her consistent with the bat or the stomping of the foot, which were the
I think we
thieves.
understand what happened. The question is, what do we do about it? I mean, this is a problem.
I believe the court can affirm it. If the court were to decide otherwise, then I believe the remedy would be that it would be the lesser included of assault with intent to murder, which would have, I suggest, no practical effect. He was sentenced to a 15 to 20 concurrent on a mayhem conviction against Nancy Moore. And everything else for the offenses against Nancy was concurrent with this charge, the armed assault, but it would presumably be concurrent with the mayhem charge. So I suggest it doesn't have a practical effect here.
Okay, and just in terms of the record, is the attachment of the indictment to the verdict slip part of our record?
It is included in the Commonwealth Supplemental Appendix. However, it's not stapled together in the Commonwealth Supplemental Appendix. But in my view of the trial file, when I went there, it was physically stapled together.
How do we know that? I mean, I guess you may have to supplement the record to indicate that it was stapled as opposed to simply being 2 separate documents. Because if all we'll see is that that there was an indictment and that there was a verdict slip. We won't know that they were necessarily stapled unless.
I'm assuming that exhibit could be transferred, I assume. I'm not really sure of procedurally the method to do it, but when I went there, it was stapled together, which is my understanding. The judge may have mentioned it was stapled also in his instructions to the jury.
Okay. Was there any motive here?
The motive evidence, certainly some sort of the defendant going into a rage. There was evidence that the Christmas preceding this, somebody had said something that he viewed as disparaging of his son, and the defendant took his family and left the house. So there's some evidence of perhaps a very strong reaction to any sort of something he perceived as being insulting. In this case, we have the homeowner, Mr. Moore, making a telephone call to his son asking for the name of the company owner, and there was evidence that he was doing that in the kitchen. There was poor insulation. You could hear it in the basement, and that would have been on the timeline when the defendant was in there installing the control clock.
And any indication that the owner was unhappy with the quality of the work?
Not prior to, the owner of the company was there. Everything seemed to be fine. So there's no evidence directly. One could infer he made that call because he might have been upset about the internet being unplugged or for some other reason. There was evidence that the internet, the Verizon coming into the house, was right in the same area as the area where the defendant was working and installing the control clock for the sprinkler system, and it was unplugged.
So the owner had left the job site, and then after that, around the time of the incident, the victim was calling the owner?
He was calling his son. Robert Moore Sr. was calling Robert Moore Jr. to ask the name of the company owner. That was Mike White.
Was there some evidence that there had been some searches for other irrigation companies online?
The victim's computer was showing that he was browsing lawn sites and lawn irrigation system sites
At the time of the incident?
at the approximate time of the incident. With respect to Dr. Fife, Dr. Fife was not asked to comment on another witness. She was asked what the impact of hearing what Dr. Abloh had to say had on her opinion. Certainly the question was proper. Her answer was ambiguous, but I do note that an expert can say that a person is malingering. So the suggestion that perhaps the defendant's account of the IBM and the takeover of the world, to the extent that she might have been suggesting that that was malingering, that would not be inappropriate.
Are you saying that she was referring to the defendant and not Dr. Abloh?
We don't know what she was referring to because the judge cut off the inquiry.
Well, she said, the judge asked, are you saying that the statements are fabricated or the report is fabricated? And she said, I'm not sure.
And it's certainly ambiguous what that means. It's unclear. But again, regardless of what she might have intended it to mean, where the jury was promptly instructed to disregard it, it was all stricken, certainly there could be no prejudice.
What do you think about asking an expert, essentially, what do you think about the other witness that just testified?
Well, that would be inappropriate. That would not be a proper question.
So what was the question here again that prompted all this exchange?
What was the impact, how did that account that Dr. Abloh testified to
The factual account.
affect your opinion?
The factual account.
The factual account.
And was there any proffer as to what you expected the answer to be?
After the inquiry ended, but the judge cut it off, the next few questions before the Commonwealth ended its questioning was about fixed delusional beliefs. So I suggest that one can infer from that this was trying to get Dr. Fife to comment about fixed delusional beliefs. And then the prosecutor just went to a more direct question about that and inquired about that.
So if Dr. Fife had said, I think the defendant was malingering and lying, there'd be no problem.
The word lying might have been problematic, but certainly an expert...
A more polite word is malingering,
A
right?
defendant, the expert could have said, yes, the person is malingering, and I believe in the Chappell case, there's actually testimony from the evidence, at least in this court's opinion, that the expert thought it was made up. What the defendant had claimed was going on was made up. So certainly I'd suggest to the extent that Dr. Fife testified and answered the question, certainly it's not clear that this was any sort of improper intent on her part. I would note there's no evidence that anyone diagnosed the defendant with schizophrenia. There was a reference in a medical record, I believe his sister had been diagnosed with schizophrenia, and I believe that had been redacted by agreement from one of his medical records, that somehow this had gotten into the record and been connected to him, and that, I believe there's some recitation at the end of the case about the redactions that were made, but there's certainly no evidence of this defendant having schizophrenia.
But this defendant was diagnosed by both psychiatrists as having psychosis not otherwise specified. Psychosis not otherwise specified.
That is correct.
So is there a big difference between that and schizophrenia?
There is a difference between that and schizophrenia. There is. Here,
This is not exactly mild depression.
it's certainly a different illness than mild depression, Your Honor. I do agree with that. But the question here was he criminally responsible? Certainly the Commonwealth didn't dispute that he did have some mental illness, and also Dr. Carroll testified about that. But the question here for the jury was he criminally responsible? And there was ample evidence of his activities after this attack to suggest that he was. Most significantly, I suggest, is the attempt to frame the co-worker by putting the bloody glove in the truck of the co-worker, which wasn't discovered until a few days later when the owner of the company happened to be using the truck.
And what is apart from it being found there, what is the basis for the inference that he tried to frame his coworker?
The defendant would have had, the coworker was banging on the basement door to get in and asked the grandson to open the door. He saw the defendant coming out. The defendant was stuffing these unfamiliar gloves into his pants. And then this glove containing the DNA of the victim turns up in a truck used exclusively by the coworker. The coworker had left the site to get lunch for the two. Certainly, the coworker wasn't there when the defendant was out on the lawn and Jamie Moore was out with his mother, but the coworker came back, and that's what he discovered. Had the defendant not been seen by the grandson and found there, this might have been perceived very differently by police. Your Honors, the Commonwealth suggests that this is not a case where this court should consider exercising its powers under 33E. Certainly, this was a brutal attack on Nancy Moore when she was poised to discover the body of her father-in-law, Robert Moore Sr. One can infer from the record that the defendant was interrupted in attempting to secrete her body when the grandson came down into the basement. When the grandson was outside, when he brought his mother outside, the defendant was out there saying, "Why, we didn't do anything, why are you calling 911? But two women happened to be walking by and saw this, and police were called. Certainly, I suggest that
Can I ask you, did it go to the jury on murder by deliberate premeditation as well as extreme atrocity or cruelty?
I believe that is correct,
It
Your
only
Honor.
came back on extreme atrocity or cruelty. They did not find
That is correct.
deliberate premeditation.
That is correct.
Yeah.
Your Honors, if there were no further questions, I would ask this court to affirm the verdict of murder and for the mayhem and other offenses against Nancy Moore.
Thank you.
Thank you, Your Honors.